Good morning and welcome to the March 1st setting of the 7th District Court of Appeals. You may have noticed we've had a panel change this morning. The first case on the docket this morning for 10 a.m. is cause number 0722-00329-CV, in re Westchester Surplus Lines Insurance Company, Relators. This is an original proceeding out of the 72nd District Court of Lubbock County. On behalf of the Relators, are you ready?
Yes, Your Honor.
Okay. Mr. Bustos, you'll be arguing?
Yes, Your Honor.
And are you sharing your time with anyone?
I'm not.
You'll have 20 minutes and a 5-minute rebuttal.
Thank you.
And on behalf of the real party in interest?
Good morning, Your Honor. Melissa Ray, representing Black, on behalf of the real party in interest, Lubbock County.
Thank you. And Ms. Ray, will you be the only one arguing on behalf of the Lubbock Independent School District?
Yes, Your Honor.
Okay. Mr. Bustos, if you're ready.
Yes, Your Honor. Thank you. May it please the Court.
Mr. Bustos.
Alice in Wonderland's Humpty Dumpty once said, quote, "When I use a word, it means just what I choose it to mean," close quote. The district's definition of the phrase, quote, "the specific amount alleged to be owed by the insurer," close quote, is just as fictional as Humpty Dumpty and Alice in Wonderland. And because the trial court disregarded the plain language of the statute, mandamus should issue. First, the plain, unequivocal language of the statute requires a specific amount that can settle the case. Texas Insurance Code Section 542A.003B2 requires, quote, this is the language from the statute, "the specific amount alleged to be owed by the insurer on the claim for damage," close quote. The statute requires those elements to be in the pre-suit demand letter. Second, the pre-suit notice requirement needs to be read in the context of subsections 542A.005 and .007. Under 542A.005, the failure to give the required pre-suit notice mandates abatement of the action, just like in DTPA litigation. Meanwhile, subsection .007 ties a plaintiff's ability to recover attorney's fees to a formula based upon the amount of the trial judgment and the specific amount alleged to be owed in the pre-suit notice letter.
What if the specific amount alleged to be owed under 003B2 is lower than the amount proved at trial?
If it's lower than the amount proved at trial...
Right. 007 talks about what happens if the amount claimed in the initial letter is higher than the amount awarded. What if it's lower?
Well, if it's lower, if you're below 20% of what you have claimed, then you're completely blanked out of attorney's fees.
What if, in this case, $20 million is specifically what they allege, but they recover $50 million at trial? Is there any, did the legislature include any consequence for including in the letter an amount that's lower than the amount actually sought?
If you did better than the amount sought in terms of the judgment, there's no penalty there.
Isn't that what we have in this case?
Well, here we don't have a specific amount alleged to be owed. To be to the point, this is a facetious demand letter. This is a demand letter where they said that it's $20 million is what they're alleging.
Is it a demand or is it a pre-suit notice?
I'm not sure there's much of a difference in terms of saying it's demand or notice. Either way, it's a facetious amount because the record reflects that they sent this demand letter and the demand letter says, well, it's $20 million, but we will never settle for this amount.
And do they have to settle for that amount?
They have to state a specific amount alleged to be owed that a carrier can rely upon and then start the settlement negotiation process.
My point's this. It's not like we have an offer of settlement where there's an offer of settlement number that's made and one of the parties says, no, I don't want that, and then there's some consequence for not accepting the offer of settlement.
That's right. It's not like the offer of settlement rule, but there is a little characteristic here that shares the offer of settlement rule. And the offer of settlement rule under Texas law, there's this 80-20 dichotomy here, and there's a punishment if you're on the wrong side of that 80-20 analysis. It's the same thing here. If you're on the wrong side of the 80-20 analysis, in terms of the amount alleged to be owed and the actual outcome at trial, there is a penalty. And the district is acting as if there can never be any type of penalty for whatever number they put in there when they give a caveat saying explicitly, we will not settle for this amount. Then what's the whole point of having this mechanism under a pretrial notice letter? Because the intent of the legislator was to give a carrier and insured time to settle a case out before litigation begins.
Is it time to settle the case or time to investigate that claim?
It could be both, but it's typically time to settle. It's typically time to settle. You know, typically an insured will go ahead and give a notice of claim and just generally say, hey, I had a hailstorm. Just let you know, I got a hailstorm, I got to look into this. And then they may retain a lawyer later on. And then a lawyer will send that pre-suit notice letter, demand letter, and they'll say, investigation's been done. We've got $50 million in damages and $5 million in attorney's fees. Here you go. And then you have 60 days with which the carrier to be able to try to get the case settled.
If the court were to look at the letter, and whether it's a demand letter or a notice letter, whatever it's called, and say the amount stated in the letter is a specific amount of $20 million, do the relators have a problem with that? It seems like the other issues on whether you can amend or what the consequences are later on are things that are not before the court right now.
That's right. That's a good point. Amendment is not on the table before the court right now. And the problem is, by the very language of the letter, it is a facetious and fictitious amount because they said some very unequivocal language. They said, quote, in their demand letters, quote, in other words, we cannot and will not resolve this dispute for the amount of damages and fees listed above. If the carriers have no idea what the damage amount really is, particularly when you have excess carriers, they sent the same demand letter to every single insurance company that was writing insurance for the district with the same amount, regardless of the fact that they had two claims for two different storm years. That is not the type of quantifiable demand that the legislator intended for insureds to send out to effectuate the public policy of trying to settle cases before litigation.
So is the argument that it's a facetious letter because of the non-settling language or the low damage number?
It's the non-settling language. That's what makes this letter defective as a matter of law.
Determining what they're actually claiming is certainly something we can't look at in mandamus review because, well, I think what the parties are fighting about. They haven't had time to adjust. There may be fact questions about what the case is really worth. We can't look at any of that. We're just bound by the four corners of the letter, aren't we?
We are. And the court can determine this case based on the four corners of the letter.
What about the second letter that was sent out to the excess carriers? I know they're not parties in this mandamus, but are we able to look at the fact that it went out to the other carriers as evidence in those issues on whether they intend to go beyond the $20 million or not?
My understanding, they sent the same letter, basically the form letter, to everyone. And there's a big problem with that with segregation of damages. Segregation of damages is important in Texas insurance law because insured has to bring a claim within coverage and segregate damages covered under one policy from those that are not, or those that are covered by another policy altogether.
If they did not include the non-settling language, but still sent a similar letter, hey, $20 million, but didn't include the settling language, would we still have the same problem? I mean, is there anything forcing them?
No, you wouldn't have. That is the key distinction here. When they say it's $20 million, but, by the way, we will never settle for that amount. We will never settle for that amount. And this is part of the record. Afterwards, on social media posts, afterwards in disclosures, they said, oh, this amount is really like $250 million.
But we don't get to look at that, right? We just look at the letter.
And all you have to do is look at that letter and look at that fatal language
My question is though, is it fatal language?
It is.
What if $20 million is the amount, and they're saying, we're willing to go to trial because we want our day in court? We want $20 million.
To have that qualifying language eviscerates the whole purpose of the statutory mechanism of the 60-day notice letter. It makes it a legal nullity. And this court is supposed to presume that the legislator did not intend a useless act. Texas law requires that in this type of litigation, like DTPA, you can't analogize this DTPA litigation in terms of the 60-day notice letter, that they have to participate in the settlement process. Texas law has said that the whole point of this process is to try to encourage settlement and discourage litigation. And by arguing that a pre-suit notice letter does not need to include a specific amount without these hedges and caveats, the district is asserting that the Texas legislature established a new statutory scheme requiring a useless act. Let me look at the legislative history with you. And a definition of the phrase, the specific amount alleged to be owed, comes from the legislative history. The bill's sponsor, Representative Bonham, faced this question from Representative Turner. Turner asked, quote, before filing a suit, the homeowner or the property owner would and their lawyer would have to provide 60 days notice to the insurance company? Representative Bonham responded, quote, that's right, before filing suit, so they may represent the claimant and they may negotiate an agreement without even filing suit or providing notice. But if they're to the step where they say, okay, now we're going to sue this insurer, then 60 days before filing suit, they would provide a notice that says, quote, these are the damages, this is how much is owed, and this is what our expenses have been. And if you don't pay this within 60 days, then we're going to file suit. The bill's sponsor, Representative Bonham, went on to say this, quote, in the pre-suit notice, what you're saying is, quote, give me this amount of money and I will go away. And this amount of money is based on the damages that we've incurred, and this is what they cost, and this is our legal expenses up to this point, close quote. Therefore, the bill's author, Representative Bonham, described a process where the claimant tells the insurer the amount owed, and then the insurer can elect to pay that amount and avoid a lawsuit. Or they can refuse and go into litigation knowing the consequences of not settling if they get a specific demand for a specific amount alleged to be owed.
What would prevent the insurers at this case from ponying up the $20 million minus the deductible and saying, we're settled, we're done?
In this case, that would equal zero. Because, again, it's in the record, there's a deductible.
There's a $10 million deductible, right?
Yeah, and there's been $10 million paid, and so it's zero. And so a demand of 20 then is another legal nullity when it comes to the facts of this case. But again, just focus on the language of the letter.
Well, my point, though, was this. If that has already been done, if the money's already been put in, then there's, I don't know that mandamus is the right relief. Maybe the right relief, then, is for the defendants to file a motion for summary judgment to say, this accord of satisfaction, we've settled the case.
No, that isn't going to be enough there, because other appellate courts of appeal have held that when a 60-day notice provision is ignored, it's abused under Section 542A.003, and the trial court denies the defendant's timely request for abatement, the defendant is entitled to seek review of the court's now by mandamus and does not have an effective remedy on appeal. So said the Court of Appeals in the Allstate case. So mandamus is proper here. This is a gatekeeping function of the trial court. And if they get it wrong, they abuse their discretion, then mandamus should issue here. This is something that should protect carriers from having to deal with facetious demands where plaintiffs are hiding the ball. They're really hiding the ball here. They're saying, well, it's 20, but not really 20. So what's the point? What is the point of having this entire process if that's the type of comments you can make?
So if the case is abated and they send a new letter and it does not have the non-settling language, but it still keeps the $20 million, are we going to be here again in a few months?
We would not. But the letter also has to have, again, these essential elements. If you look at the statute grammatically, there are a couple of different clauses here, and this has application to the excess carriers as well. The specific amount alleged to be owed, that's the first vital clause. So that has to be done unequivocally without hedges and without takebacks. And then the next clause in the statute is by the insurer. Therefore, when you send one $20 million demand to every single carrier, like half of them are excess carriers that aren't primary carriers, then are you really alleging a specific amount alleged to be owed to each of the carriers? And the district...
But we've covered that issue with regard to Stowers claims in the past, right? You don't have to Stowerize each defendant or each insurance company individually. You can make a single offer, and then that's good to cover the primary carrier and the excess carrier. Wouldn't that be applicable here?
No, it wouldn't be. And there's a third reason why a generalized shotgun blast letter is not going to be effective. The last clause in that statute is on the claim. And again, we had 2 different claims, 2 different years, but we get an identical letter for $20 million. So they have to...
On each claim, you got an identical letter on each claim?
Yes, the 2019, the 2020 claim, they both said $20 million. And so you need to follow the statute, and it's not that hard.
Your argument on the time frame, that's B1, I'm assuming that's what you're arguing?
Right. And so, we have excess carriers here, and the district knows full well the tower of their insurance coverage, and it's not hard. Allege a specific amount alleged to be owed by the insurer, on the claim. It's not that hard. It's A, B, and C. It's only when you try to be facetious and cute and hide the ball and try to shotgun your way into getting into litigation and trying to run up attorney's fees will you run into a problem. The legislature did not do a useless act when it enacted the statute. And the district's arguments, again, are facetious. The district's argument, and this is their own language, that, quote, there is no penalty for giving a low notice letter. A policyholder could literally give a notice letter saying, quote, we have $1 in damages, close quote. That's their argument. It could be as low as that, as long as it's the bar super low, so we can make sure we always win attorney's fees. That flies in the face of the statute's plain language. Let me talk about the cases that the other side is relying on and why they don't help them. The Triple H Properties case. Interestingly, that is another Daly and Black case.
Let me cut you off and back up just a minute.
Sure.
You were responding to Justice Yarborough's question a while ago that said if we send this thing back and they come back with a second letter that doesn't have all the other surplusage in the discussion, and it's just a $20 million letter, the insurance company would be fine with the $20 million letter, correct?
If it meets the 3 elements of the statute. Go ahead, I'm sorry.
No, I think I understand. It's got to meet the 3 things. It's got to state the specific amount, it's got to identify by the insurer, and it's got to include the claim that it's being settled on. All right.
That's correct.
Back to the $1 discussion you were having just a minute ago. There's nothing that would prevent them from giving the specific number. You may not agree that that's the reasonable number as long as it's a specific number, right?
It's a specific amount alleged to be owed. That's what counts.
Without regard to whether it's a reasonable number or they think it's worth really more or really less, it's a specific number. That's all the plain language of the text requires.
And that's all I'm asking this court to do is to enforce the plain language of the text. If they say it's $1 and remove all this qualifying caveat language, well then, and you meet those other elements, then you've got an effective letter.
I'm trying to make sure that the insurers are not expecting this court to say, we think that the damage amount would actually be this amount or some other amount.
Absolutely not. That is not this court's province. You're not fact finders. You're not, and the cases don't speak in terms of reasonableness at all. They speak in terms of compliance with whether you gave a specific amount alleged to be owed.
So the plaintiff, the district, can be unreasonable in the number it gets as long as it gives a specific number and meets the other provisions under 543A.
That's right. That's what the statute requires. Their Triple H Properties case does not provide guidance here. Again, that's a Daly and Black case. And it's not applicable because in that case there was a specific amount alleged to be owed. That fact was not in controversy or disputed. Also, the demand letters in both cases were different. Our letters have the huge qualifiers that say we cannot and will not resolve this dispute for damages and fees listed above. That language did not appear in the Triple H Properties case. And lastly, no other court, as of a couple of weeks ago I double-checked, no other court has ever cited to the Triple H case in the 5 years it's been issued. and I would urge the court to not follow this case as well, as no other court has. The Mount Canaan case, it's similarly distinguishable for the same reason. There was no dispute as what the specific amount alleged to be owed was in that case. Therefore, that makes it inapposite to the case at bar. The district filed a supplemental brief about the Concat case from Judge Fish in the Northern District. But in the Concat case, Judge Fish found that there was, in fact, a specific amount. This is part of his quote language. The pre-suit demand letter's specific amount. That's a quote from Judge Fish. So again, that's far different from the type of notice letter we have here. We have caveat language where they say, here's a number, but we'll never settle for it, to where insurers are left guessing and having a hidden ball to have to deal with. On the same day that Judge Fish entered the Concat decision, he entered the Sarwar versus General Star case. And in that case, he found that fees were not going to be awarded because the demand letter failed to have a statement of the acts or omissions giving rise to the claim. That's another part of the statute. You have to have a specific amount alleged to be owed. And in that case, he found, well, you missed out on this one because you didn't have a statement of the acts or omissions giving rise to the claim. And there was a consequence that went with that decision. The consequence was the plaintiff was not able to recover attorney's fees after the date the defendant filed its motion against attorney's fees. I'll come back. Thank you.
Ms. Court? Mr. Bustos began by saying, when I use a word, it means just what I choose it to mean, and not 30 seconds later told this court that it doesn't matter what the statute says. It doesn't matter whether it says notice or demand, that it's basically the same thing. And it's not basically the same thing. The legislature has, in other contexts, had a demand requirement. Chapter 38 of the Civil Practice and Remedies Code requires a demand for payment prior to filing suit. If they wanted to require a demand, it would have been the easiest thing in the world to use that word.
Why does it matter here? The requirement is that you state a specific amount. You either state a specific amount or it's not specific.
That's right, and we did. And I was a little confused by the attempt to distinguish the letters in the Mount Canaan case and the Concat case, and I do have copies of both cases and the letters for the court if you'd like to follow along with them. They're very similar to this case. They say, they're round numbers. In the Mount Canaan case, it's $1.5 million. That was an estimate. It was a round number. They said we don't have everything that we need yet to give you any more than that. And in the Concat case, the letter said this is a very conservative estimate of our damages. We expect it to be more. We're still getting reports, that sort of thing. If I may approach, I have a copy of both cases and letters to the court.
Yes.
But I guess my question is, without regard to what these federal courts have said, I mean, obviously this is a question of Texas law. If you say $20 million, but we don't mean it, that seems to not be a specific amount.
It is a specific amount, though. It's a specific number.
We have to read the entire letter in context. There's nothing that requires that you use numerals. You could say, I want to get paid whatever the amount Alex Rodriguez got paid in 1997. I don't know what that amount is, but that could be a calculable amount. But to say whatever that amount is, and then say, but we're going to go after something different, appears to not be specific as to the amount being claimed.
Well, that's essentially, though, if the court, when you look at the letters in the Mount Canaan and the Concat case, you'll see that that's essentially what they said there, that this is an estimate. It's a round number. It's an estimate of what we believe our damages are. And I don't know if they're wanting something that's not an even number, something that has dollars and cents. We have a number in there, and what in the Triple H case, what Judge Werlein said is...
Well, I think what counsel responded to a moment ago in response to Justice Yarbrough's question was, if you sent out another letter that said our demand is, or whatever, our claim is for $20 million without the additional we reserve the right to do other things language, then they're satisfied with that amount, because that's a specific amount. So I think the question is really, does all the other language that follows the $20 million amount constitute something that makes your original number gray?
No, not at all. Not at all. There's nothing.
So would you have an issue then if we were to conditionally grant mandamus relief and you were to send out a letter saying our demand is $20 million?
We would not send out because the statute doesn't require us to send a demand.
Okay.
We're only required to send a notice.
What language would you use? You would say a notice of $20 million.
We would use the language that's in the statute, which is the specific amount alleged to be owed is $20 million.
Without the rest of the language saying we reserve the right to take it back or to seek a greater amount, et cetera.
Sure, we could take that language out, but that doesn't mean that, the purpose of the statute is to give the insurers an opportunity to make a settlement offer. It's not intended to be a demand letter. It couldn't be a demand because under the statute, under 542A, it encompasses breach of contract, bad faith, prompt payment act claims. But
the problem you've got, though, with your argument on that is you've got excess carriers whose coverage does not kick in until the noticed amount is greater than, say, $50 million. If you send out a letter saying, we're giving you notice of a $20 million claim, and you send that to an excess carrier, the excess carrier doesn't have notice of anything.
Well, they have notice. This is a tower of insurance. It's a manuscript policy, a follow form policy. While their indemnity obligation may not kick in until a certain amount has been paid, whatever their layer is, they still have obligations to the insured. They still have obligations.
They've got a duty to defend, maybe, but I guess in a third-party claim they would. First-party claim, they might have a duty to investigate, but they don't have an obligation to do anything else until there's a greater amount presented that would kick in their coverage.
But I don't think that that's intended. And for one thing, if you look back at the legislative history, and I believe this was addressed in the amicus brief, the testimony that they reprint in there is Representative Bonin talking about how an insured is supposed to meet this burden. How is an insured supposed to know what do they owe me? And he talks about your typical residential roof case and says, well, they just have to call a contractor or maybe get an adjuster to help them figure out how much they're owed on their claim. We're not talking about a situation where you have a $15,000 residential roof here. We're talking about 20 insurance companies, multiple layers of coverage up to $250 million, an insured property that has 60-plus campuses with more than 200 individual buildings or structures that are damaged. And the insurers, Mr. Bustos talked about us shotgunning into litigation. The storm was in May of 2020, and in April, when we sent the notice letter, the insurers had not produced a single damage estimate. Not one. They had not produced any damage estimates. But they say to us, you haven't produced any damage estimates. You haven't produced any causation reports.
Right, that's what the statute requires you to do on the claim.
No, it doesn't. It does not, respectfully, Your Honor. It does not require...
I don't mean you're statutorily required to conduct that. I'm saying part of hedging your bets about whether you're right or wrong on the number would be to do your own due diligence and determine what that amount is.
And we have been doing our due diligence, but what the insurers are telling us is that we are required, in order to even give them notice that they have failed to adjust our claim for 2 years, we're required to do what they are still telling us literally as of yesterday is still not finished. It's still an ongoing adjustment process.
That appears to be a problem that you've got with the legislature and not one that the Court of Appeals necessarily has to face.
But I think we're getting a little bit beyond what we need to look at, though, because what we need to look at is what does the statute require and what does the letter say? And what the statute requires is, or the only thing that's in dispute here, at least in the petition, is the specific amount alleged to be owed. It contains that. I think when you look at the cases, when you look at the...
If you break up Section 2 on the specific amount owed by the insurer, I want to focus on that section. We sent 2 letters. Is it specific to each insurer? Is it just $20 million to all of them? I know we had the discussion with the Stowers.
Well, so the first letter went to one group of insurers, and the second letter went to another group of insurers. We're alleging that the group of insurers, our insurers, it was sold as a block of coverage as a single, unified tower of insurance, that we are owed $20 million by our insurers. What's also interesting, though, is, and this goes back to, is it supposed to be a demand? Is it supposed to be, there's nothing in the statute that says that our notice can only include the things that are listed there. In fact, in the Triple H case, Judge Werlein really, I think, didn't like our letter very much. He said, well, they don't like the statute, and he even said, it's clear that even if you tried to settle with them, they wouldn't have settled with you. They weren't going to settle. And he was totally fine with that. He said, the purpose of the statute is to give the insurers an opportunity, or the insurer, an opportunity to make a settlement offer.
Well, they're bidding against themselves at that point, aren't they?
Well, they're bound to pay what they owe on the claim. And I'm sorry, I didn't mean to interrupt you.
You're saying the statute puts the burden on the insurance company?
Well, the insurance company has a burden under the policy and under the insurance code to investigate the claim and pay what's owed. And incidentally, we've talked a lot about what the statutory intent was, and that's a theme that's constant throughout the insurer's briefing, is that Judge Souter's order somehow frustrates or negates or offends the purpose and intent of the statute. Well, let's look at what the insurers say is the intent of the statute. First paragraph of their petition, they say it's to address lawsuits motivated by profits and not actual damage to real property. Let's be very clear, there is no dispute that there is significant damage to Lubbock ISD's 60-plus campuses, and maybe we don't agree on the exact number, but a number of campuses and buildings. In fact, we have gotten damage estimates now from the insurers that total about $30 million last I heard. So that concern, that's not something to be concerned about. If the legislature was concerned about lawsuits that involve a couple of shingles, that's not the case here. So we don't have to worry about that. Insurers also say the purpose of the statute was to address exaggeration of damages. They've never alleged that we exaggerated our damages. In fact, we know from their own estimates that $20 million is not an exaggeration of the damages here. So we don't need to worry about that. In fact, the number in the notice letter came from the insurer's third-party adjuster. After 2 years, when the claim still hadn't been adjusted, the district hired counsel, and Mr. Daly talked to the third-party adjuster and said, in an attempt to resolve it without litigation, said, what are we looking at here? And he said, well, I've reserved 40, but at least 20. And so Mr. Daly said, okay, that's what I'll put in the letter then. And the truth was, he didn't know at that time what the amount of damage was, because, we have 60-plus campuses, 200 buildings. It would cost the district millions of dollars to come up with what they allege specific amount to be owed is. But that's not what the statute requires. And, Judge Hainan explicitly rejected it in Mount Canaan, and then Judge Fish in the Comcat case. The fact that those parties may have phrased it as a demand, that's fine, but that doesn't change the analysis, because the statute doesn't say this has to be a number you're willing to accept today. And if they wanted to say that, they could have said it. And it wouldn't make sense for that to have been their intent, because what the statute says is that you have to allege the specific amount to be owed on the claim for damage to damaged property. Well, 542A and the statutory notice requirement encompasses cases, any weather-related claims. So breach of contract, you have bad faith, you have potentially DPA, you have Prompt Payment Act. You have a number of different types of claims that can also, under which you can also recover other types of damage besides just the amount that it's going to cost to fix my roof or to fix my property. You've got consequential damages, you have bad faith, trouble damages, you have prompt payment interest, which in this case is millions and millions of dollars, which is why we couldn't possibly settle for the amount that we allege to be owed for property damage. So if the legislature had intended for it to be a demand, number one, they would have said a demand, and number two, they wouldn't have limited that requirement to just the property damage.
What about the language in B1 that also requires you to give specific notice of the claim? My understanding from the record here, there are two and possibly a third hail damage claim that we're dealing with multiple insurers, some of whom may not have been in the game the first time that a claim came around. It doesn't seem like your letter's providing anybody specific notice of anything.
Well, and this is, talking about being cute and doing things cute. We filed a claim in May 2020 because that's when our roof started leaking, right? And a year and a half later, the insurers come and say, our engineers have decided that they think that some of these properties were actually damaged in a storm in May 2019. So they were not represented by counsel at the time. District representatives talked to the third-party adjuster, working with him, between him and the broker. Everybody's very involved in that. And they're saying, well, I mean, the insurers are saying that, that some of this damage may have been in 2019, so if they're telling us this, I guess we ought to file a claim to cover our bases. And Mr. Cimino and the broker, they all say, yeah, you should go ahead and do that. And now the insurers are trying, we didn't make a claim for damage for 2019 until the insurers came to us and said, oh, here, we think there's this other storm, and by the way, it implicates more insurers and, different coverages.
I understand that may be difficult on your end, as proof of these types of injuries always are, but the statute requires you to provide them notice of the claim. So why not at least segregate your claims and say, we believe this damage of this amount was caused by the 2019 storm, this damage was caused by the 2020 storm.
But it doesn't require us to provide them notice of the claim and segregate damage and say, this roof was damaged on this day, this roof was damaged on this day. This is a very basic notice requirement. And if the legislature had wanted us to have damage estimates, they could have said that. They've done that in other statutes, and you can't even file a med-mal case without an expert report. If the legislature intended for us to act in good faith, like they've said on and on, this is unreasonable, this is not what they'll really take, they weren't acting in good faith, they could have used those words specifically, and they have in other statutes, but they didn't do it here. And maybe, regardless of what everybody can get up here and say, oh, this representative said this and this lawyer said this, the statute says what it says. And it says we've got to allege, and the only thing that they have said we didn't allege is a specific amount to be owed. And what at least Judge Fish interpreted that to mean is there a number in there? Doesn't have to be reasonable. It can be vague, he said. It can be ambiguous, he said. It just has to be a number. And there is a number in there. And I'll agree, the statute as the statute is written, we could put $1 in every notice letter. And you made a great point about the legislature not penalizing in 542A lowballing. It's just not there. And that was the first point that you made, Justice Doff, is that that's not there. It penalizes, and that just goes back to, it's to address exaggeration of damages. It does address exaggeration of damages.
I guess the question that I ask, though, with regard to lowballing when you've got excess insurers is, are you putting them on notice of anything if you don't put them on notice of a claim within their range of liability? If you're a $50 million insurer and I send you a claim saying my claim is $1, they say, I don't have to do anything at this point because I'm an excess insurer. That's not notice.
It is notice, but they can file a motion for summary judgment if they think that you don't have a claim against them for that amount. That's not something that's addressed at the notice letter stage. Another thing that Judge Hainan said in Mount Canaan is that it's okay if the number goes up later. In that case, the insurer had sent subsequent letters that were demand letters that had higher numbers, and Judge Hainan said that's okay.
We're not here on that part at this point because that issue hasn't been decided by Judge Souter, and we can't take that on mandamus relief to determine whether he's abused his discretion or not.
Well, we are here, though, on whether or not the letter states a specific amount to be owed. And what I understand their argument to be is that the only reason they think it's not a specific amount to be owed, and I wrote it down twice, is because of the non-settling language. And that's certainly not supported by the statute, and it's not supported by any of the case law. I would also point out, the insurers tend to say, oh, well, the statute intended to tie the plaintiff's ability to recover attorney's fees to the relationship between that number. And again, that's just not an accurate statement of what the statute says. It's intended, or not intended, it says your ability to recover is not tied to that. It's tied to whether or not you overstate your damages, not understate them. Again, there's no penalty for that, no good faith requirement, and they have a remedy for it. They have a remedy. They can go to the jury, and, I mean, the statute specifically says, and this actually was not in Representative Bonin's original bill that he introduced. It was added by the House Insurance Committee. It says you can bring it in and show it to the jury. You're not limited to, to what the number was that you put in your notice letter.
That's Section G of the statute, right?
You're right. I just realized that. I was about to correct myself. What was added, however, is also relevant, though, because what was added says that nothing in the notice letter limits you from presenting additional evidence of the amount of damages, attorney's fees, et cetera, that you can put on at trial.
Is the insurer's response letter admissible under Section G as well?
I don't believe so, no. No, I think it's just the notice letter that is admissible. And I would point out, the overarching thing in a lot of these cases is that, not specifically B2, but that the statute generally is intended to give them an opportunity to make a settlement offer, an opportunity to attempt to resolve the case. And they did that. They sent us a long letter where they said, okay, well, I guess it's resolved then because we've paid $10 million, there's a $10 million deductible, and we know you're probably going to reject this, but we're going to tell you anyway.
Well, that seems relevant, though, on the Prompt Pay Act portion of the statute, to say, look, we put the money in the registry of the court, it's paid, all the interest, time periods cut off because your offer or statement or notice, whatever you want to call it, was $20 million, and we said we accept. I mean, again, we don't have to decide that today. That may be something we look at final judgment, but that's the risk of making a lowball offer, is that the insurance company could accept it and say, fine, that's what this is about.
Except that it's not required to be a demand. I mean, if the statute said we have to make a demand.
I understand for purposes of what we're dealing with today. My point is the consequence may be something that affects you later on down the road with regard to a prompt pay argument.
Potentially, but I agree that that's not really what we're here about today.
Your time is up.
Yes.
Do you have further questions?
I don't have anything.
Mr. Ray? All right. Thank you very much. Mr. Bustos, you have 5 minutes.
May it please the court. Let me follow up on a few questions the court had. The attorney fee provision of the statute is designed to punish plaintiffs who make unreasonable demands. It's also designed to punish carriers if they don't settle reasonable claims by making the insurer pay legal fees. So that's why the 60-day period is important. If the carrier gets a specific amount alleged to be owed and makes an intelligent decision saying, no, I think that's too high, then the carrier from there on runs the risk of getting statutory interest against them and attorney's fees and punitives, all types of things. But the 60-day window is there to allow a carrier to be able to settle a claim that they can actually put their hands around and isn't ethereal.
But here, what if the $20 million was too high?